And can you think of any disadvantage to collaborative law?
Well, some clients actually, most clients love it, but some clients are uncomfortable with the idea that the lawyers have to withdraw from the case, because actually there are clients around who actually like their lawyers and don't like the idea of starting up again. But I think that what happens, there is a problem if the collaborative process fails. You make a pretty big investment. But the statistics are pretty good. Most cases settle, and I think it's worth a try for most people. I think as a collaborative practitioner, you do have to be careful if the clients have limited means, whether it's really a good idea for them to spend all they have on the collaborative process and then be stuck without the funds to hire a litigation lawyer.
Yeah, because I do have the collaborative law training, and I'm a member of the collaborative bar. But I find when I present it to clients, they often say, well, but you're the one I want if it goes to trial. I don't want to have to use it. It really, they become skittish at that thought of having to get a different attorney. Now, we all know, what, David, 98% of all cases settle?
I'd say so. The final analysis, before the actual trial starts, probably 98%.
It could be on the courthouse steps. It could be while you're waiting, and we're outside. But 98% settle. So the chances are pretty slim that that's going to happen. But I want to ask you something, David. From your, before we get into you as a mediator, you on the bench, did you feel that you could sort of size up the attorneys and know who the more cooperative attorneys were, who the more reasonable attorneys were? Did you get a sense of that from the bench?
Very definitely. I mean, you knew as a judge, and I was doing it for 27 years, but you don't have to do it for that long. You knew which lawyers are straight shooters that'll tell you, what the law is. They'll accurately report it, the facts, and so on. And then there are lawyers who just misrepresent, and they get a reputation, and right as soon as you see that lawyer appear in front of you, you have a credibility issue, and you know this is the lawyer who's always been a straight shooter, and this is a lawyer who's never been a straight shooter. And the real test of being a good judge is not letting your prejudice, not penalizing the client because he's got a lawyer who isn't always straightforward with the court. But I'd say it's pretty quick. Most judges have a pretty good handle on who is a straight shooter and who isn't. And lawyers develop a reputation.
And how do you distinguish who's driving the case? Because it could be the client who's unreasonable, and you can't control them completely, and they say, I don't care, I'm going for alimony. And you say 400 times, this isn't an alimony case. And then you have to stand in front of the judge and make a case for alimony. So, I mean, would you put that lawyer in the category of somebody you don't trust too much?
No, if he's an advocate, so he's got to present his client's issue. But you get a pretty good idea at the pretrial stage. When it's pretrial, you read the memoranda and you see what the case is all about. When you start suggesting to both the clients and the attorneys what the outcome may be depending on the pretrial memoranda, you see lawyers shaking their head, yes. You know it's not the lawyer's problem, and you see the client going like this, you know it's not the lawyer, it's the client. But I always used to tell the clients, if I thought a lawyer was unduly litigious, I would say, look folks, you work hard for your money, you've got a choice today. You can resolve your case today, and you'll get a 5-minute hearing, it'll be over. Or you can use your hard-earned money to educate your attorney's children instead of using it to educate your children. You make the choice. Yeah. If you want to educate your attorney's children, keep fighting, folks. Yeah. If you want to use your funds to educate your children, I suggest you be open-minded and resolution-oriented. So you got a pretty good idea as to who was resolution-oriented and who wasn't.
You know, until they're ready, they're not ready. I told you the story of the woman who, after 10 years, the husband had moved out of state, and then it took her 3 more years. You know, until they're ready, they're not ready. And I find that with settling the case, there's sort of a lifespan of a divorce case. And once they're ready, it settles. And no matter what you try to do before they're ready, they just can't do it. And usually it's an emotional thing. We have a caller. We have a call.
Yeah, hi. My name is Carl.
Oh, hi, Carl. How are you doing?
I'm doing well, thank you.
This
isn't a question about me, just so you know. But I want to know, I have some friends who are contemplating divorce, and they always talk about, well, you know, he did this as bad behavior, and so I don't know if I should divorce him, or is that going to count against him? I guess I'm wondering, does it matter if someone's cheating on their wife? Does that hurt them in the settlement? Or, does it matter who's at fault for the breakup of the relationship?
Okay, terrific question, Carl. Thanks for calling in. I guess the question is, do we have no-fault divorce in Massachusetts, or does behavior count?
Behavior definitely counts, but not to the extent that most people think. There's 16 factors that a court will consider in deciding a case, and their age of the parties, length of the marriage, health of the parties, and so on. One of them is conduct of the parties, and everybody thinks that a case is going to rise and fall depending on the conduct. I'd say conduct unless there's some brutality involved, unless there's some severe physical abuse. But as far as an affair is concerned, as far as conduct is concerned, it's probably the least important factor.
Well,
And so, but people think it's the most important factor. It really isn't.
well, because it's the one that hurts them the most, so they
That's
want to
right.
they want to get to that. But how I describe the conduct factor is that when the court cares about the conduct is really if it impacts the marital estate, which is not who you're sleeping with, but if you're keeping them in a little love nest somewhere and you're paying a fortune to have this, and you're dissipating marital assets because you're paying someone else's rent, then they care about your conduct. So
But I wouldn't want the caller to think that his friend can go disregard their marital vows and pay no penalty. It's my experience, and the judge, obviously judges feel, for the most part, the way Judge Kopelman feels, but in the real world, most cases don't go before judges. And when you're negotiating a settlement, if there's a lot of emotion and a lot of feeling, and if there's infidelity, usually the guilty party will pay for it, in my experience.
Well, and the caller, thanks for your question, because what he brought up was if there's violence in the marriage, if there's domestic abuse, domestic violence or physical abuse, or even verbal abuse, which leaves sometimes worse scars than the physical abuse. Are candidates, are people who have had abusive relationships, are they good candidates for collaborative law? And then I'm going to throw it to you about the mediation.
Well, I think that for most, unless there's some documented diagnosable pathology, I don't think the fact of there being some an isolated incident of domestic violence would necessarily disqualify the case for collaborative. But if the cases can't, if the clients can't be in the same room with each other, then it's not going to work.
How about, let's talk about mediation, because I promised Newton that we would get all three prongs of this in. Mediation, just describe the process. What's your role as a mediator?
Typically, mediation involves the two clients come in with their attorneys. They present what they would like to achieve, their objectives and goals. And what I like to, and they present some kind of a memorandum that I can read. And what I like to tell them is, look, I'm no longer on the bench, but if I were on the bench, and I think most judges, there's some continuity of thought, this is what I think would be likely to happen, A, B, C, D, E, F. And my suggestion is that you try and be a little realistic with one another and work it out. One of the problems with going to trial is that people are hurling spears at each other, and they make deep wounds, and they're not forgotten soon. So in a mediation, people are explaining what their objectives are in a civilized fashion. If they're not civilized, they're put into two separate rooms. But once you go to trial, all the dirt comes out, all the hate comes out, all the anger comes out, and you can't take it back. And you've got to live, a couple has to work with each other if they have children for 10, 15 years to come. And it's very difficult to work with somebody who's been telling the world that you're a lousy parent. Not a good thing.
Guess what I just figured out? It's longer than 10, 15 years.
It can be,
Because
yeah.
I'm a grandparent
Well, you got the
now. I'm a
grandparents.
grandparent
It's
now,
generational.
and I'm with my ex-husband at my grandchildren's birthday parties.
Right.
So they're in your life forever,
Right.
if there are children. If there are children, they're in your life forever. I mean, whoever the spouse was. But there's the traditional wisdom, anyway, is that mediation is better for the reasons you say in any situation where there was going to be a relationship afterwards. It could be employer-employee, it could be landlord-tenant, trying to resolve some dispute, and certainly with divorce, when, and particularly if there are children involved.